So today I'll be speaking about the legalization of cannabis and the employer considerations. So a bit of an overview about what we're speaking about today. First I'll speak broadly about drug and alcohol policies, then I'll move to accommodation, then handling suspected impairment, then drug testing, and then mandatory disclosure and discipline. So I have a lot to cover today. I do want to mention that this is a continuation of one of my previous presentations that I did in last year's fall seminar on the legalization of marijuana. In that presentation, I went further in depth into drug testing and various ways that you can drug test an employee. So I recommend that you look at that video at your leisure if you haven't already. So a bit of an overview about legalization. So cannabis and its derivatives, including marijuana, were legalized on October 17th, 2018, so we're just past the 1-year threshold. And just a bit of a reminder of the impacts that marijuana has on users. It can impact concentration, the ability to think and make decisions. It decreases reaction time. It can impact the motor skills and cognitive functioning, and it can increase anxiety and panic attacks. Interestingly, the medical research that's coming out is showing that marijuana users have a difficulty assessing their own fitness to work and continue to make errors on tasks without awareness for up to 24 hours after consumption. And this is coming through into the courts through that expert evidence, and I included one case there where an expert spoke at length about this fitness to work assessment ability. So drug and alcohol policies generally. So just a bit of a recap, if you do not have a drug and alcohol policy, that's something you certainly should do. And I included some of the key points on the slide from last year's lecture. About drug and alcohol policies generally, they should include a clear and express statement that the policy promotes safety and is to deter unsafe behavior in the workplace. It should also include a consistent prohibition on the use, possession, intoxication at work, or during workplace events. It cannot single out marijuana. So much like you can't single out Tylenol users, you cannot single out marijuana users in your policy. It should encourage and require employees to disclose substance abuse issues without a fear of reprisal or discipline. So I know a lot of employers want to have a complete zero tolerance-based policy in their workplace. However, you do need to accommodate drug and alcohol dependency disclosures, and I'll be discussing that a bit later. And it should provide for and explicitly set out a process for employees to ask for and obtain treatment. So one of the new decisions from April of this year is Miller Waste Systems in Charlevoix. The background for this case is an employee smoked marijuana, or it could have been another substance, but it's very clear that the employee was lighting a substance in the workplace, and this was videotaped by a supervisor doing so. It is important to note that Miller Waste Systems was a very safety-sensitive environment. It was a waste recycling plant, and so therefore there is a huge fire risk in that particular workplace. And the employer had a drug and alcohol policy in place that prohibited smoking in the workplace. And so as soon as this conduct was discovered, the next day the employee was terminated for cause under the policy. The employee brought an Employment Standards Act complaint, and this the ESA officer determined that he was terminated for cause, and that was upheld, and then it was upheld again on appeal to the Ontario Labour Relations Board. So just a bit of a reminder for those of you who may not know, there are two different standards for cause. So there's the cause under the common law and there's cause under the ESA. I previously presented on that in a prior presentation, but just a bit of a refresher. Under the ESA, an employer is required to provide notice of termination or pay in lieu unless the employee engages in willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So the OLRB decided that smoking in the workplace is willful disobedience that is enough to substantiate cause in one occurrence. So this was seen as an intentional and a deliberate act, and smoking in the workplace caused a risk of fire and a risk of injury to the employee and others in the workplace, and was a direct contravention of the Occupational Health and Safety Act, the Smoke Free Ontario Act, and the Fire Code. bit about accommodation now. So what marijuana use needs to be accommodated? So just a bit of a reminder here that recreational drug use is not a human rights issue and does not need to be accommodated. So similar to alcohol, employers can limit and restrict the recreational use of marijuana and prohibit impairment at work. And employers can require disclosure of impairment due to recreational use, similar to other over-the-counter medication. With that being said, addiction from marijuana needs to be accommodated. If you might recall, marijuana has approximately a 9% addiction rate. So employers can request disclosure, time away for treatment, return to work only upon medical clearance, and other methods to ensure abstinence from future use. And then there can also be use of marijuana due to an underlying disability or illness, and this needs to be accommodated. Just a few notes that employers can and should require the disclosure of an authorization from a doctor and the underlying medical issue. You can request information about the prognosis. Keep in mind you cannot request information about the diagnosis. For instance, you can get a prognosis that marijuana is being used due to backaches or shakes, but you can't get the underlying disability. You can request information of the duration of use of the marijuana, the form of ingesting, the scheduling of use, the limitations that the employee would have when they are consuming cannabis or marijuana, the accommodation suggested by the practitioner, the level of impairment during use, and the impact on the performance of their duties. So a couple of my employer clients will ask me, when can they say no to marijuana use? This is something that is basically fact dependent, and I strongly suggest that you seek legal advice. However, some considerations to keep in mind are safety, the bona fide requirements of the position not being met, and undue hardship following treatment and failure to remain abstinent. Medical marijuana must be accommodated to the point of undue hardship. Some things to keep in mind is that Health Canada has shown that there is a potential for several hours of residual impairment after the initial use, stemming up to about 24 hours. The level of use is something to also keep in mind, including the amount, the timing, and the duration. Safety-sensitive workplaces have unique concerns, and the current limitations on being able to conclusively test impairment are currently weighing in favor of the employer. However, it does raise some issues, and I'll be discussing a bit about that later. So I have this case, the IEBW Local 1620 and Lower Churchill Transition Construction Employers Association, and this is also a decision from this year, post-legalization. And so this was a unionized grievance. It involved the construction of electricity towers, so it was very clear that this was a very safety-sensitive job. So the employee obtained this job conditional on a pre-employment drug test, and this was set out in the collective agreement. And prior to subjecting themselves to a drug test, the employee did disclose that I do use medical marijuana, and this was every night to treat his osteoarthritis and Crohn's disease, and therefore it triggered the disclosure of a disability and the need to accommodate his use. And as soon as he disclosed his cannabis use, he was refused the job, so it wasn't in dispute. That was the reason he was refused the job. And he had also worked a previous safety-sensitive job with the same union, and he was permitted to work with no incidents. So in this particular case, the employer had no way of accommodating the employee in the position. Therefore, the denial of the position was a good faith occupational requirement, which would be the ability to work unimpaired. This is very unique, and it's important that the employer had no other jobs available in a non-safety sensitive position. All positions with the employer required physical dexterity and mental focus, a deficit in which, due to the nature of the work, the equipment, and the work site, created a severe hazard for the worker and others. And this is where it's discussed about the current testing, the current technology with respect to drug testing, which I did speak about a bit last year. But as of right now, the employer has no way to reliably measure impairment from cannabis almost instantaneously, which is what the court seems to suggest. So there's a severe risk of harm that cannot be effectively managed due to that fact that the individual could be impaired up to 24 hours after, and then undue hardship arises because the employer has no reliable way to test. I did speak about this a bit last year, but I would suggest implementing oral swabbing, although most employers are still doing urinalysis. Unfortunately, while there seem to be some developments in breathalyzer, that isn't quite at the level it needs to be yet, and so I would caution against using a marijuana breathalyzer, which is being developed. And so this case determined once the possibility of impairment was raised by the employer, the onus shifts to the employee to demonstrate to the employer, to their reasonable satisfaction, that they could perform the job safely without accommodation. So handling suspected impairment. Some things to note when you're looking for impairment are odor, physical appearance, unsure movement, slurring or sleeping, memory loss, agitation and personality changes, erratic or uncharacteristic behaviors, poor coordination, extended breaks, particularly alone, and nearby paraphernalia. So basically you're looking for changes in the employee's mental, physical, or behavioral differences. And that's for most drugs. I have created a checklist which would help employers if it's in your folder for those of you who are in attendance. But basically what to do if an employee exhibits signs of impairment. Obtain information regarding the conduct and behavior of the employee. So on this checklist, it lists out various symptoms of being impaired due to drug or alcohol use. I would strongly suggest putting it with your drug and alcohol policy. For instance, it's a checklist. It indicates 1, smell of alcohol or other substance on breath of person, and it's yes or no. So the supervisor that's reporting to this can basically fill out the checklist so it's very clear what the employee is exhibiting to convince the supervisor that the employee is impaired. Because a lot of the time people just naturally think, oh yes, this person is impaired, but they don't have the articulation of why they are believing that. I would suggest interacting directly with the employee to determine the behavior, personality, and reaction time. Ask the employee directly if they have recently used alcohol, cannabis, a prescription drug, or a narcotic, and if they say yes, ask them why, to make sure that there's no disability or accommodation issues. Indicate your concern regarding the employee's behavior or impact on the current condition on that employee's ability to perform their duties. Provide immediate health assistance if necessary. Do not let the employee return to work or be alone or operate machinery or a vehicle. Provide an escort home. Take notes from everyone who has interacted with the employee. Confirm any authorized uses of medical marijuana or prescription drugs. And allow the employee to provide an explanation of his or her conduct, and that one's very important. And drug test if necessary, and I have a little asterisk because I'll be speaking about that in a moment. So just a bit of recap on drug testing. Unionized environments, all drug testing must be in the collective agreement, full stop, there you go. For non-unionized environments, it's a little bit more tricky. For non-safety sensitive environments, and keep in mind there isn't a clear definition what constitutes a safety sensitive environment, it is unlikely that any drug testing in any circumstances will be justified. So therefore, I would recommend going through this drug and alcohol policy impairment checklist. So you have a non-bodily fluid drug test, and then issue a written warning indicating suspected impairment. Suspected impairment must be treated like any other performance failure, ideally with a written warning and progressive discipline, or termination with reasonable notice. For safety-sensitive positions in non-unionized environments, reasonable cause or post-incident testing is typically allowed if it's part of a larger assessment. Random testing, it's a bit of uncertain right now, and consult legal counsel. Pre-employment testing, once again, it depends. And last chance agreements as part of a return to work after substance abuse treatment is permissible if tailored to the individual's circumstances and includes further accommodation. And once again, I spoke about that in the previous presentation. So tips for drug testing. If an employer is going to engage in drug testing, At a minimum, they must critically review whether the job is determined to be safety sensitive, try other less invasive methods first, use a reputable and reliable form of testing and testing provider, ensure the tests are conducted promptly, ensure the test samples are handled and exchanged properly, ensure that a backup test sample is maintained, ensure that the employee's privacy is maintained, remove the employee from the workplace while the test results are being determined, and testing must be connected to a purpose of minimizing or deterring impairment at work or job safety. So if you recall, last year I had a 2018 case to look out for, which was the ATU Local 113 and TTC. So just a bit of a follow-up on what that case determined. So in that case, if you may recall, TTC won the right to conduct random unannounced drug tests until an arbitral resolution was reached. Based on the publicly available information I have, the union has actually conceded to random unannounced drug testing. So under the random drug test, 82 of 4,299 employees tested positive for drugs and alcohol or refused to test, and 62% of the positive drug and alcohol tests involved the use of cannabis. So it is interesting to show how when there is random unannounced drug testing, it can result in showing that there is a drug and alcohol issue in the workplace that could further justify any random drug tests. So mandatory disclosure and discipline. Just a bit of a recap again. The courts have upheld some drug policies that require a worker to disclose their current drug use or be at risk of discipline or potential termination have been upheld. And I refer you to the Stewart and Elk Valley Coal Corp decision, which indicated that these mandatory disclosures in the policy must include that all voluntary disclosures be accommodated. So some general considerations when disciplining an employee for their drug or alcohol use. These are questions that the employer should ask themselves before implementing any discipline. Was the misconduct connected to the impairment, mental illness, and or addiction? I.e., is there a disability that needs to be accommodated? Should the employer have been made aware of the disability? Should the employer have made a reasonable inquiry of addiction and or mental illness? Is the employee authorized to use marijuana medically? Should the employee have disclosed their permitted use? And was the employee able to or should have been able to disclose their addiction prior to breach of the policy? That concludes my presentation. I think we're going into a networking and coffee break.